I'm going to call the day to order. I had been under the impression that we were starting, at 9:30 and not 9, but we're kind of free-flowing here. Since we have one speaker from BYU, this reminds me of an occasion when I double-booked myself to be both BYU and San Francisco State on the same day for a Constitution Day event. Although I won't go into the details, I actually felt I was in the right and that somebody else had screwed up along the way. In any case, so this morning's panel is going to involve us in a set of discussions which deal primarily with the subject of relations between Congress and the presidency. With the exception of Alison Lacroix, I hope that rendering is okay.
LaCroix, actually.
LaCroix, okay.
You were more French.
It's been anglicized. Who's going to have to explain the relationship of her paper to as I told her last night at dinner, to the rest of the session, because it's not the neatest fit, but it's still quite interesting nonetheless. I think we're going to move more or less chronologically. So we'll start with Aaron Nilsson first, and then Mike Paulson, and then Nick Perillo. I'm sorry.
Perillo.
Yeah. Perillo. I'm sorry. Oh, my mistake. Actually, we'll start with Mike first. Yeah. Mike, then Aaron, then Nick, then Allison. But before we get to that, I have one opening quotation I want to make on our general subject. The issues we're dealing with, I think I've thought about a lot, at least in a general sense, from my perspective, is primarily a historian of the adoption of the origins of the revolution and the adoption of the Constitution and politics in the 1790s. And the guiding text that's always driven my thinking about this issue is particularly on the specific kinds of questions we're dealing with today, comes from a passage in James Madison's 37th Federalist, which was in effect the second. There are two introductions to the Federalist. Federalist 1 is the first. Federalist 37 is the second. If you look at the first printed hardcover edition, the famous McLean edition, for which I once had a sweatshirt, which I left up at the Nixon School one day after playing basketball. But Federalist 37, which is a deep epistemological reflection on the nature of Constitution making itself, has a number of astute observations. And one of these, I think, is worth mentioning here. Madison says, "Experience has instructed us that no skill in the science of government has yet been able to discriminate and define with sufficient certainty its three great provinces, the legislative, executive, and judiciary, or even the privileges and powers of the different legislative branches. Questions daily occur in the course of practice which prove the obscurity which reigns in these subjects and which puzzle the greatest adepts in political science, among whom he numbered certainly himself, and I also think Montesquieu. I'm finishing a paper on Montesquieu's influence on Madison for a conference in Paris a few weeks down the road. So I think having that underlying epistemological insight in mind, which was, I think, a deeply self-conscious reflection on Madison's part of the whole experience of Constitution making, and including the remarkable novelty of what had taken place at Philadelphia in the late spring and summer of 1787, is a really useful insight. And I think especially if one is a historian like myself or my young colleague here, Jonathan Knapp, who are very much engaged in these kinds of debates, but who bring a certain kind of skepticism, let's say a kind of critical skepticism to the whole endeavor. And what I, or perhaps Jonathan as well, think about this, may come up later in this morning's sessions. In any case, so apologizing briefly for the misconception that they had me starting a few minutes late, which I hate. I pride myself on being punctual. Nevertheless, we'll now pick up. And my general rule here is, I think, I won't be hard-ass about this, but about 10 to 12 minutes per person, introductory, and then we'll see where we go from there.
All right, thanks, Jack. Good morning, everybody. It's great to be here back at Stanford. I am not a Stanford Law School graduate. I'm a Stanford Law School dropout. I actually came here and started law school and then left after 5 weeks because the weather was too nice and everything. It was just too beautiful. So I graduated from a second-rate law school in Connecticut, whose name shall not be spoken in these hallowed halls. I'm honored to be invited to be here. It's been a truly illustrious group of people. Yesterday's papers and presentations absolutely blew me away. They were just spectacular. You having trouble hearing? Okay. Should I start all over with my opening jokes? No. The papers yesterday were just, gosh, wow, super fantastic, brilliant, insightful, thoughtful, scholarly, and I'm tremendously impressed. I'm honored to be part of this, and thanks to the organizers, Michael and Jed and Morgan, for putting together such a stellar conference. So, since the assigned theme for this panel is early presidential construction of constitutional power,
I'm just going to push it closer to your face.
I'll pull it closer.
Perfect.
Okay. So the theme is early presidential construction of constitutional power. I thought I would talk about the most important constitutional interpreter of the very first presidential administration, and one of the handful of the most important interpreters of the U.S. Constitution in all of American history. My working title for the paper is The Interpretive Force of Alexander Hamilton's Pseudonymous Expositions of Presidential Power. Now that's a mouthful, so I might end up shortening it to The Interpretive Force of Alexander Hamilton. Hamilton was a force, right, and a force of constitutional interpretation in the early days. The theme of my paper is that Hamilton is the most important and deservedly influential early presidential, that's spokesman for the administration, interpreter, applier, construer, expositor of presidential constitutional power in the founding era, and with a special emphasis on the areas of war, peace, national security, and foreign affairs. And he was also the most influential early interpreter, setting forth the fullest, best early explanatory account of the text structure and logic of operation of Article II's allocation and assignments of the executive power. So the paper, which is half written and in the process of being revised, as all good academic papers are, tries to do three things. First of all, it makes a methodological point of why Hamilton's writings count as good but not necessarily indirect or second best evidence of original meaning, right? What makes early interpretations or early practice probative of constitutional meaning? And in the course of doing this, I'm going to sort of hypothesize a theory of what counts as evidence of constitutional meaning. So that's the first thing the paper tries to do. The second thing is to look very briefly, necessarily sketchily, at the early pseudonymous writings of Hamilton as Publius, Pacificus, and Camillus. Publius is the pen name for the Federalist Papers. Here, this is a very well-worn, tattered copy of the Federalist Papers. It's all good originalists should have a very marked up copy of the Federalist Papers. Pacificus is the series of essays he wrote in 1793 defending the Washington administration's constitutional power to issue the neutrality proclamation in the war between France and its revolutionary enemies, in particular Britain. Very influential series of essays in 1793. And then Camillus was the pen name he used for defending the lawfulness of the Jay Treaties in 1795 and 1796. So I will look at that. I won't talk about that today because there just won't be enough time unless we get to it in the question and answer period. The third thing the paper tries to do is to sketch out an argument that Hamilton was right on essentially all respects in his exposition of the Constitution on all of these points of war, foreign affairs, powers, and structure of Article II. Hamilton marked the path that all others have followed or responded to or debated. And I believe he marked the path rightly in foreign affairs, treaty making, treaty interpretation, and war powers. Now, I don't have time in 10 minutes to address all these points, so I thought I would just drop down to the one point of methodology, and that is the question of why Hamilton counts. What is the probative force, generally, of early practice, early interpretation, early precedent, as a matter of understanding the Constitutional's true original meaning? Now, a lot of this was sort of implicit in the discussion in yesterday's panels, looking at precedents from the early first Congresses, but why does it count? And I think the answer depends on what your theory is of constitutional interpretation. What counts as evidence of the Constitution's meaning depends on what you think the enterprise of constitutional interpretation is all about, what it is, what is constitutive of constitutional meaning. If you're a pure, evolving constitution, living constitution, non-originalist, much of this discussion that we had yesterday and today is almost irrelevant. How does that constrain if your model of constitutional interpretation is basically that the text doesn't even necessarily control? Why should the history control? The only reason you examine the history is to refute all these originalist claims that the Constitution has a determinate meaning. If, on the other hand, your theory of the constitutional meaning is that early practice liquidates or establishes or defines the meaning of the Constitution, then 1790's practice fixes the interpretation and is actually more probative of constitutional meaning than 1780's original sources. And in that sense, you would attach priority to the early interpretations. Turning to various originalist theories of constitutional interpretation, if your theory is that what counts is the original intention of the framers, their subjective intentions or expectations, what the framers actually meant to do, you would accord primacy to the records of the Constitutional Convention. The debates of the Constitutional Convention, they reflect the understanding of the framers and the intentions. And the idea of looking at early practice would not be actually very meaningful because that would not have been evidence that would have been available at the time of the Constitution's adoption. If your theory is that what counts is the original understanding of the ratifiers, the ratification conventions is what gave life to the meaning of the Constitution, then you would not look to the records of the debates at Philadelphia, the Constitutional Convention. You would look to sources like the ratification debates. What did they understand the document to mean? Things like the Federalist Papers would take on greater importance, diminished by the fact that it is not available record at all of the ratification debates. And early practice would again not be relevant, right? Because this was not something that was available at the time that they're debating the Constitution, how it was actually implemented 5-10 years later. If, however, your theory is that what actually counts in constitutional interpretation is the original objective meaning of the words of the text. This is what I think is the correct understanding of constitutional interpretation. That the enterprise of constitutional interpretation is to faithfully ascertain and apply the meaning that the words, texts, structures, logic, principles of the Constitution would have had to reasonably inform speakers and readers of the English language reading a document of this type at the time and in that political community. Then all of these sources become relevant because the enterprise is not looking for anybody's subjective intentions or expectations, but looking to the meaning of the words, sort of an objective, abstract concept. So it would all count, the records of the Constitutional Convention, the debates, the ratification debates, the Federalist Papers, and early practice and early interpretation, but it might count differently and be given different weight. Now, just a word of caution about early precedents. Early precedents or practice of any kind, I think, while useful information about the understood meanings or range of meanings of the Constitution's terms, simply cannot be conclusive of constitutional meaning. Practice does not define constitutional meaning. The Constitution's text is the standard by which to judge the lawfulness of historical practice and early events, and not the other way around. So I think that early precedents should hold a distinctly lower position in the hierarchy of sources that you consider in interpreting and understanding the original meaning of the Constitution. That doesn't mean it is for naught. It means that you have to be cautious about applying it, and this has a limited actual probative effect. Early practice and interpretation deserves consideration as potentially good evidence of what the right answers were, but not because they're constitutive of constitutional meaning. They're persuasive evidence of meaning to the extent you have confidence in the interpretation that has been rendered at the time. So with that preface, why does Hamilton count? I think Hamilton counts significantly, not because of framer veneration. His views are not important because he was Hamilton, and Hamilton was actually not a very influential figure at the Constitutional Convention. You don't read Hamilton because he's necessarily authoritative legislative history concerning the development or formation of the Constitution. Even under a ratifiers matter most theory, most of the Federalist Papers are expositions or explanations of the Constitution that however spectacular in their analysis, were not actually part of the debate in most of the states that ratified the convention. Much of this discussion and most of the papers on presidential power are written late at a time when they're not really available for most of the ratifying conventions to consider. Rather, I think that the reason you read Hamilton is, well, several overlapping reasons. First of all, he displays the meaning of words and terms that are used as understood by an intelligent, informed person. He is sort of your classic, fully informed, understanding individual who employing these concepts, and that's probative evidence, second best evidence of what they actually mean in practice. More than that, he's a highly sophisticated, informed, astute legal analyst. You can read the Federalist Papers and the Pacificus essays as a form of learned commentary by somebody who's very skilled in legal analysis, and that actually helps to display the meaning of the words. Third, the writings of Hamilton were part of the real-world debate and actual deliberation. In a sense, Hamilton was in the arena. This is not just, when you read Hamilton's Pacificus essays, Camillus essays, and the Publius essays and the Federalist, you are not just looking at actual practice of what was done, you're looking at what was actually formulated and argued and defended. And I think that's important. Finally, and I think this is the most controversial point, and I'll probably draw some fire from the administrative law people. Hamilton was often, in effect, speaking for the executive branch in his interpretations. Now, maybe a little less so in the Federalist Papers, except by way of anticipation of the expectation that Washington would be the first president. But Hamilton's interpretations and analysis concerning matters of war, peace, foreign affairs, neutrality, including his pseudonymous writings, arguably constitute early official or quasi-official executive branch interpretations of a document that the executive branch, along with the other branches, is charged by oath with faithfully interpreting and applying. So if early practice counts for anything, can I borrow 2 more minutes?
No.
No.
It's too much.
Okay. We'll do 30
Maybe 20 seconds.
If early practice counts for anything, early executive practice counts fully as much as early congressional practice and judicial interpretation. And there's even an argument, and that by analogy to the administrative law doctrine of Skidmore deference, that where the executive is charged with carrying into effect a general legal enactment, the executive's interpretation should have a force. I think that applies to most of Hamilton's writings. It applies clearly to the Pacificus essays when he is acting on, even though writing supposedly anonymously, he's basically writing as the administration's spokesman, articulating the administration's official interpretation. Camilla's essays are 1 year after Hamilton has left office, but again, they seem to represent the official views of the Washington administration. In other words, Hamilton's voice
Mike, Skidmore
spoke
deference is a good place.
for Washington. Okay, thank you.
And we can pick up with Camilla's later. Aaron, over to you, and we'll have our first PowerPoint presentation
Yeah.
here for visual diversion and
Welcome to
substantive
the
education.
20th century. All right. Okay, here it is. So I'm going to present a paper. This is a paper I wrote with Chris Walker, and here's the backstory. So a couple of years ago, I got a surprising opportunity. Now, for some of you here, the opportunity to argue about the constitutionality of removal restrictions would be kind of second nature. This is what you do. You're, constitutional historians and theorists. I am a simple country game theorist, and it was a little bit of a surprise. So I asked many of the people who have spoken at this conference, we had long conversations, to try to get the best argument left after say la law to defend the constitutionality of removal restrictions. And we put together a brief. Chris and I, we worked really hard. And it was a massive defeat for the Amigas. We lost everything. And in fact, because we had so many good arguments from so many people in this room, now all of those arguments have lost as well. Justice Alito went line by line through our brief and decimated any of the arguments, I think, left for the idea that Congress has the power to impose removal restrictions on the executive, especially for single-headed agencies. But analytically, I don't see how it works for the multi-member agencies either. The only thing left of Humphrey's executor, I think, is stare decisis. After this, it doesn't matter how much power the agency has. It doesn't matter if the agency regulates ordinary Americans or not. Even if the president can fire the person for policy disagreement, that itself is not good enough. All of these arguments are now gone on a 7-2 vote. Justice Kagan joining for stare decisis reasons. Okay, so you think maybe there's nothing left of this, at least for those who want to actually kind of argue about these things. We can have history and that's fun, but in terms of like real world effect, for at least a generation, maybe the argument is done. Well, Chris and I, as we were looking through these original sources, with a brief coming up, so you have intensity of review, we realized something, which is everybody talks about the president's removal power, but if you read the original sources, whatever the answer is on that, which is debatable and we've seen for the last couple of days, it's clear that Congress has what we call the anti-removal power, which is our putting a title on a whole bunch of things that the Congress can do to make the president not use his removal power, thus de facto creating a measure of policy independence within the executive branch. And here's some proof of this. So first, we're going through the Federalist, and we see Federalist 76 and 77. And this is Hamilton. And Hamilton's explaining the importance of the Senate in the Appointments Clause process. And he's saying why we have this process. And I like it. He talks about the silent operation of Senate confirmation is, one, to keep out rascals, but two, to provide, in addition to this, it would be an efficacious source of stability in the administration. And then he goes on in the next one, he explains what he means by that. And this is what we heard yesterday from Elon. But there's a debate about whether that means that the Senate has to be a part of the removal or whether it's just you replace the person, then you need the Senate to go back to them to reconfirm the new replacement. But either way, Hamilton explains, so either interpretation works for our purpose, where a man at any station had given satisfactory evidence of his fitness for it, a new president would be restrained from attempting to change in favor of a person more agreeable to him by the apprehension that a discountenance of the Senate might frustrate the attempt and bring some degree of discredit upon himself. In other words, if you have to go to the Senate for confirmation of your people, there's a chance that they will say no. So if before you can go off and replace somebody, you have to kind of think really hard, is this going to actually happen? I can't just get what I want. All right, we say, okay, well, Hamilton, maybe Hamilton's a squish, maybe he doesn't know what he's talking about. All right, Madison. Madison, the person who is, the main advocate of presidential removal, he has his debate in, a part of the decision 1789. Read the entire speech. He goes further and he says, but you don't need to worry. You don't need to worry about giving the president removal because the president is going to hesitate to use this power. And in fact, if the president uses this power in a really bad way, you can impeach the president for removal. And then he goes on and says, obviously, which again, that didn't happen, but I mean, it's a pretty strong thing to see, kind of an arresting thought to see. But he goes further and says, what happens if the president removes somebody? Well, this person usually is a person of high stature, a lot of respect in the community, certainly going to have powerful friends in Congress. And what they're going to do is they're going to make it harder for the president to be reelected, or they're just going to make the president's life miserable. So, and he goes on to say, to displace a man of high merit and who from his station may be supposed to be a man of extensive influence are considerations which will excite serious reflections beforehand in the mind of any man who may fill the presidential chair. In other words, it's the silent operation that Hamilton's talking about. The mere fact that if you remove somebody for a bad reason means that people are going to come after you by itself is a reason that you're going to be inclined to keep the folks who are there. Well, this is where the game theory comes in here. So think of this through. I think this is what they are saying. They didn't use the jargon of modern game theory, but I think this is exactly what they're saying. So imagine this. Imagine a world where the president can say, I can fire anybody I want and instantaneously get the exact person that I want at no political cost to myself. If you could do that, if there is such a world where the president can immediately say, you're gone, you're here, and you're going to do exactly what I say, what policy result should we predict? Here, let's imagine that we have any question. Let's put the spectrum between less enforcement and more enforcement. What's going to happen is you would expect the policy result to be exactly where the president wants it. Why? Because if the person doesn't do exactly what the president wants, the president will instantaneously remove that person and put the person in his place, will do exactly what the president wants. Game theory says it's going to collapse into exactly the president's policy preference. Right? Well, that's not the world that we live in, and never has. Instead, we live in a world where there are costs associated with removal from the president's perspective. Most obviously, to go back to Hamilton or Madison, the person that you fire probably has powerful friends in the Senate. That's a lot of what you end up in one of these positions is a powerful senator. So if nothing else, you have just ticked off a powerful senator. That matters because you're going to have to negotiate with that person for other things. But beyond that, you'll notice when most of the time these firings occur, like today anymore, it's like the Friday news dump. Because presidents know that if you fire somebody, there's going to be nasty press. That is not a new thing. That has always been the case. So the president says, you know what? If you are pretty close to where I want you to be, good enough. That's close enough for my purposes. I will keep you around. It's only when you start getting really far away from my policy preferences that I'm going to kick you out. So in other words, to use the jargon of game theory, a president will have an indifference range, where, in other words, if you are within that range of policy, you are close enough for my purposes, I will keep you. Now, for certain positions, say the Secretary of State, the indifference range is going to be almost the same exactly of the president's priority, because the president's going to say, if you are my Secretary of State, this is so important to me, you're not doing what I want you to do, I will take almost any political cost to have my foreign affairs policy where I want it. So there, the president's indifference range is almost exactly the same as the president's preference. But for, say, a less consequential position, the president's indifference range can get fairly broad. And we're going to talk about an example of the comptroller of the currency, which a president, as far as we can tell, has never removed. In the 160 years the office has been in place. It's not on anybody's top of their list of the most important positions in the government, and presidents simply don't fire these people. But here's the point. The Constitution, this is the anti-removal power, the Constitution gives the Senate or gives the Congress power to increase the president's indifference range. thus increase the measure of policy independence of executive branch officers. Here's an example, easiest example, Senate confirmation. There's somebody that the president doesn't like in a particular position and says, I would like to fire that person. Well, the president has to say, well, there's the political cost I'm going to have to deal with, but there's also a real risk, to go back to Hamilton, that the Senate isn't going to confirm my replacement. So it's a little bit the devil I know versus the devil I don't. If this person doesn't get, I replace them, and they don't give me the new person that I want, the president has to discount the value of the replacement by the probability that the Senate isn't going to confirm the replacement. Right? Or it's not going to happen instantaneously. It's going to take a long time, so the president has to have the time value of the policy and discount it again accordingly. But the point is, Congress has the power to make, go back here, to make it broader. And there's more than that. This is where you can talk about, they have the power to control their own rules of procedure. So they could bake into their rules, if you fire this person, there will be a hearing. So you want to do this on a Friday afternoon? Go ahead. There's going to be a hearing. This is going to be part of what we do. And there's nothing you can do about that. If you ex ante build that into the rules, the president knows it's now more politically costly. Thus, the president's indifference range gets broader and broader, which is policy-making discretion by this particular official. And it's baked into the system. This isn't the same as for-cause removal. For-cause removal, you're going to have out here policies that the president would say enough, but there's nothing he can do with. But for most of the time, there's a pretty good argument that the president's going to be in that space, and the particular official is going to have policy-making discretion because the president's going to say, it's close enough for my purposes. It's not good enough for me. You're not so far away from my preferences that I'm going to fire you. And I think this is exactly what Hamilton is saying in Federal 76 and 77. I think it's what Madison is saying. But here's the thing about it. It actually works in the real world. I thank Professor Baumzai for this one. You go back to the comptroller, which was created in the 1860s. The comptroller's only protection for removal is the president has to give reasons before he fires the comptroller. And you go back to the debate about this particular requirement, and some of the senators are like, this is essentially the dumbest thing we've ever heard of. Because all it has to say is a reason. It's Thursday, I don't like you, you're fired. What kind of restraint is that? That's no protection at all. To which some of the other senators, who I think had a better sense of practical political judgment, says that's not actually how it's going to work in the real world. Because the president's going to know that if he blows off this requirement and gives a poor reason for it, we're not going to confirm the successor. We're not going to confirm the successor unless the president gives a good reason. So the mere fact that the president knows that we care about this position, the mere fact that he has a reason, means the president isn't going to remove this official in the real world. And that has proven correct. Chris and I have gone back and looked at 160 years of the comptroller. And there are some cases where the president has leaned on somebody pretty hard and got them to resign. But we have not found a single example of a president removing a comptroller. And that's even in recent times. So for a long time, President Trump had President Obama's comptroller. Until recently, President Biden has had President Trump's. And you're like, wait a minute, these are actually have pretty significant policy differences. Even so, presidents keep the position, which I think entirely is in line with the theory of indifference ranges. This isn't the Secretary of State, it's the comptroller. And it's not enough for the president to take the political blowback and keep the position. Once you recognize the dynamic, we're going to go through this. I'm not going to go through this here, read the paper. There's all sorts of tools that you can say this. This is something that there's the age, should we get rid of the filibuster? If you want to have policy-making independence in these agencies, you need the filibuster, because this is what the Senate can do. The Senate can say, I'm almost there. The Senate can say, you know what? The cloture vote for our this such and such position is 2/3. By itself, that is going to make the president discount the value of removal because it knows it's very, very hard to get a replacement. There's also anti-evasion tools, and all of these things are built in. At the same time that the conservatives are making it harder for presidents to remove, they're also making it hard for the presidents to avoid the Appointments Clause process, thus creating a greater measure of real-world independence. And now here's the last point, and then we're done here. The last point is this all we have Madison, we have Hamilton, but is this a deliberate feature of the Constitution, or is this just a strategic, after the fact, looking at the tools, you can create it, but is this how the system was supposed to be built? And this is where Jen Mascott yesterday talked about the Sinking Fund Commission. I'm going to talk about that as well. It's a bizarre thing where you had like the Chief Justice and the Vice President and all of these sorts of things. Our point, for purposes of our paper, is regardless of whether or not that disproves the unitary executive, it certainly shows anti-removal power. Because can you imagine the president firing somebody and then have the vice president, who was a political rival at the time, saying, "What a horrible thing you've just done, President." You have a built-in political constituency in favor of the people on the Sinking Fund Commission. So in a dog that did not bark fashion, it suggests that the first Congress was aware of these political dynamics and kind of built it into the system. And that is where we will go from here. Thank you.
And that's a wrap.
All right.
Thanks. Next up, Nick.
Thank you.
I'm being too generous here, but say what me.
Thank you, Jack, and thank you to the organizers for bringing us together. So as we've been talking about, one of the most important executive powers is the power to appoint executive officers, as Article 2 calls them, the officers of the United States. The Appointments Clause says that all principal officers must be nominated by the President and confirmed by the Senate, and all inferior officers are appointed that same way by default, but Congress has the option to provide for these inferior officers to be appointed instead by the President alone, or by the courts, or by the heads of departments. So, if an officer is to be nominated by the President and confirmed by the Senate, does the Appointments Clause mean that the President and the Senate must have a completely free choice in who to choose? Or if an officer is to be appointed by the head of a department, does the Appointments Clause mean that the head of a department has to have a completely free choice? Or alternatively, is it constitutional for Congress, when it creates the office in the first place by statute, to say that anyone who fills the office must have certain qualifications? This question about qualifications is one on which there's almost no case law. The executive has repeatedly asserted that there is some constitutional limit on Congress imposing qualifications for officers, but the executive is usually vague about what that limit is. Sometimes the executive has asserted a categorical limit, as when George H.W. Bush claimed that all qualifications for principal officers were unconstitutional. And some scholars have also argued for categorical limits, including the idea that all qualifications for all officers of the United States are unconstitutional. Going to Michael's methodological discussion earlier, the Constitution's original meaning on this point has been debated in terms of text, pre-ratification discourse, structure, and early practice. Now, when it comes to early practice, the source that everybody most relies on is Brandeis's dissent in the Myers case, which catalogs hundreds of statutory qualifications for officers that were enacted from 1789 through the 1920s. But of all the statutes that Brandeis compiled with qualifications for officers of the United States, there's only one that is within 30 years of ratification and therefore seems highly probative for original meaning. And that's the one that everybody always cites. It's the Judiciary Act of 1789, which said that the Attorney General and the U.S. attorneys had to be learned in the law. But there's an argument that the Judiciary Act is not strong evidence for the constitutionality of statutory qualifications, because this provision about government attorneys having to be learned in the law is inconsequential. The job of the Attorney General and of the U.S. attorneys is to represent the government in court, and any president would appoint trained lawyers for those jobs, regardless of whether there was a statute saying that it had to be that way. So my aim in this paper is just to point out some other legislation near to 1787 with officer qualifications that I don't think can be as easily dismissed as inconsequential, and this is legislation that was missed by Brandeis's catalog. The legislation is the direct tax of 1798, which Congress imposed on all landholders and all slaveholders across all the states. The legislation set out to raise a set dollar sum, $2 million, and it apportioned that sum among the states according to each state's free population plus 3/5 of its enslaved population. And the dollar quota that was apportioned to each state was to be raised from the taxpayers of that state in 3 stages. First, every slaveholder paid 50 cents per enslaved person. Second, every owner of a house paid tax on the value of the house according to certain progressive rates. And third, every owner of land besides a house, which is to say every farm, paid on the value of the land at whatever flat rate was necessary to make up the state's quota. So as you see, this tax required a value to be assigned to every piece of land in every state. And to assign these values, the legislation created the largest corps of federal officers for any federal function outside the military of the Constitution's first 2 decades. The officers came in 3 tiers. The bottom tier of these officials were the assistant assessors. They assigned taxable values to all pieces of land in the first instance. The middle tier were the principal assessors. They decided appeals from landholders who complained that their parcel had been valued out of proportion to other parcels in the area. And the top tier were the commissioners. Who were the commissioners? Well, Congress divided every state geographically into an odd number of federal tax divisions and said there would be 1 commissioner for each division of the state, nominated by the president and confirmed by the Senate. And in each state, all the commissioners in all the state's divisions were grouped together to form a federal tax board covering that state. Each federal board had 4 major powers. First, the federal board can appoint all of the assessors covering the state. Second, the federal board can impose regulations on all those assessors. Third, the federal board can divide the state into federal tax districts. And fourth, the federal board can uniformly raise or lower the taxable value of all parcels in any district by any percentage, quote, as shall appear to be just and equitable, unquote. That is, the federal board covering the state decides en masse the relative taxable value of land as between the state's geographic regions. This legislation of 1798 gave no definition of the value of land. It provided no methods for determining it. And there was no background consensus for how to do land valuation. Then, as now, deciding real estate values was indeterminate and contestable, and it was also politicized. When the state governments each imposed their own real estate taxes, the relative value of land as between each state's geographic regions was decided directly by the state legislature, and it was the object of intense political controversy in the legislature. Which is to say, this direct tax officialdom in 1798 had a lot of power with political implications. Now, all 3 of the officials under the direct tax were subject to statutory qualifications. Now, let me say something about those and why I think they mattered. So, the assistant assessors and the principal assessors, the bottom tier and the middle tier, all had to be freeholders. That is, they all had to own land themselves, and they had to own it in freehold tenure, not as tenant farmers. Now, freehold property ownership, I think, was not necessary in an instrumental or functional sense to having the knowledge and experience in agricultural business that would be relevant to an assessor's decisions. For example, tenant farmers are not freeholders, but they were a diverse demographic, and some of them were successful in agricultural business and they were sophisticated about it. Rather, The freehold qualification, I think, reflected an early modern political ideology that only freeholders had the requisite independence and stake in society that were necessary for participating in government. Still, we might ask, was the statutory exclusion of, say, tenant farmers superfluous in the sense that any federal board in appointing assessors would never have appointed tenants just because of the ingrained political prejudice against tenants among the governing class, regardless of whether there was a statute saying anything about the matter? And I don't think it was superfluous. Appointing tenants might have been impossible to imagine back in the colonial period, but during and after the Revolution, half the states start allowing tenants to vote, and New York and Pennsylvania make tenants eligible to serve as state legislators, which a few of them did. And then also, of the 9 state governments that taxed land by value as of 1798, 3 did not require their assessors to be freeholders. And then lastly, there was also a statutory qualification for the highest tier of officials, the commissioners. The commissioners each had to be residents of the intrastate divisions for which they were respectively appointed, meaning that every board was geographically representative of the state that it covered. The geographic representativeness of each board mattered for a couple of reasons. First, it meant that each board had collective expertise about the land across all the state's regions. And second, geographic representativeness made it more likely that each board would have political credibility with the people of the state that it covered. And such political credibility was important because the board is deciding the distribution of taxable value across the state's rival political regions. In conclusion, I'll note that the president at the time, John Adams, accepted these statutory limits on the executive appointment power in the sense that he signed the legislation and made no public objections to it, and his nominations of the commissioners actually conformed to the residency requirements, with one exception that, on the basis of Adams's correspondence, I argue was unintentional, but we can get into that in the Q&A. Thank you.
Well, I'd like to thank Nick very much for saying, it's a little too late in this session to say you've set an admirable example, but even so, you've done very well. Allison, over to you.
Thank you very much. Thanks to the organizers, and I'll add my note of thanks there, and it's wonderful to be part of this conversation. So, as Jack noted, my contribution here is a little bit different, but I regard that as a virtue, and I will endeavor to explain why. So it's a chapter of my book, which is forthcoming and being published by Yale University Press. And the title of the book is The Interbellum Constitution, Union, Commerce, and Slavery in the Age of Federalisms, plural. And so the focus of the book is, and I can talk more about this, but just sort of quickly, to talk about this period between 1815 and 1861, the interbellum period between the War of 1812 and the Civil War. And the book argues that this is a distinct period, which it turns out is itself an argument on which I have been challenged by people who say basically there wasn't any constitutional thought in that period, or it's just kind of the period between the real moments. But my argument in part is that this is not just the between the real moments approach, and indeed making a methodological point also that I think constitutional history and theory are too focused on moments and shocks and particular instances. And so there's a sort of moment-driven analysis that I'm challenging, and also I think with that an amendment and text-driven focus. Nothing happened between the 12th Amendment and the 13th Amendment because there were no amendments between the 12th and the 13th Amendments. So therefore, it was just this sort of fallow period of working things out, liquidating, and so forth. And then there's a kind of fixation assumption that goes with this that also, again, says, well, things may have happened in this period, but they were political or technological, but they weren't really constitutional lawmaking, and I think that that's not right. So I guess I would put on the table also between the poles of originalism and living constitutionalism, the common law constitutionalism that my colleague David Strauss has written so much about, because I think the focus in this period, as you see in this chapter, very much for me is bringing lawyers out, but not just lawyers, other producers of constitutional discourse. So we have Justice Johnson writing Circuit. The justices on Circuit seem to have felt sort of free to not quite frolic and detour, but to maybe push the envelope a little bit doctrinally. And then others, so the chapter alludes to Mariah Henrietta Pinckney and plenty of others who are kind of not in the courtroom, but are still producing constitutional discourse. Okay, so what then is this interbellum constitution that I suggest existed, and what did it comprise? First is this pervasive concern with federalisms, plural. So I think it's a period that often in retrospect is seen as the beginning of things that came later. So the Civil War and Reconstruction, the 20th century civil rights movement, the New Deal. And so people, I think, go looking in this period for a federal-state dichotomy. And when you are a hammer of federalism, you find many state nails. But there's actually a lot more going on. So that's why I'm talking about federalisms, because we have many different competing levels. I think this ties in with some of Nick's work as well, all the way up to the foreign affairs and diplomacy level, all the way down to the micro level of the harbor master and the sheriff in Charleston, who through the chain of letters, constitutional interpretation, directives, are in some way in privity with John Quincy Adams talking to Stratford Canning. The sort of doings of the harbor master at Chisholm's Wharf in Charleston were the focus of intense attention in Washington and in the executive branch. And now the real focus here, and the reason for the question about fit, I think, is that I'm looking at the 1820s in this chapter. And so, you know, it's interesting, again, with this project, this sense that what is this period I'm looking at? Is there constitutional thought going on? And yet you open any constitutional law casebook and it is rife with the Marshall Court and its precedents. So one is confronted with the M's, as I think of them, Marbury, Martin, McCulloch, then Gibbons versus Ogden, a host of others. And then there's this sense, though, that none of that was actually creative in some way, that was, again, carrying out, whether one thinks Marshall was the great Chief Justice or not, there's the sense that this was a sort of plan laid out. We just kind of needed a precedent. So I really love teaching, for instance, Martin versus Hunter's lessee or Gibbons versus Ogden, because students think essentially there just needed to be a case you could cite for the obvious precedent that the Supremacy Clause is a real thing. And it's like, no, these were actually contested. So I think the 1820s really fit into this constitutional history in an interesting way, because there's a self-consciousness of people in the 1820s about their relationship to the founding. They constantly think about this. That's why people produce these multi-volume biographies, not just of George Washington, but of Patrick Henry, Nathaniel Greene, you name it. Someone thinks they can write a multi-volume biography, make some money, and also kind of enshrine themselves as the children of the founders. So the 1820s, I think, are really interesting because what do we have going on, especially in South Carolina? Well, I would argue this circuit court case that Justice Johnson hears involving the South Carolina police bill, Elkison versus DeLisaline in 1823, is actually the real nullification crisis in some sense. So refocusing, I think, the attention from Calhoun and that kind of nullification theory to say, here's a federal court judge who is very much of Charleston, embedded in Charleston, has his own revolutionary lineage, his mother stowing ammunition in her petticoats, his father in the trenches outside Charleston, who says, my reputation is the property of the Union. He's a South Carolina Charlestonian planter slaveholder, and yet he says it violates the foreign commerce power and the interstate commerce power to have a South Carolina statute saying that any free black sailor who comes into any port in the state has to be jailed while the ship is in port, even if they're British subjects. And so Johnson hands down this very strongly worded, completely irascible, says way too much, says he's not going to talk about things and then talks about them, opinion, which is great. And South Carolina, in many parts of its officialdom and planter class, ignore it. Others don't. The South Carolina Attorney General refused to defend the statute, or didn't show up, but it was pretty clear he didn't agree with it. And so the state essentially says, we have nullified a decision of the federal court, What are you going to do about it? So it's the real nullification crisis, or at least another real nullification crisis. It's also about a fight to control the founding and its meaning. These children of the founders, Pinckney, Johnson, others, who really view themselves as not just guarding legacies, but actually sort of carrying forward the substantive views of their parents. It's a fight to control the local, which I think is not the state. It's a kind of local power struggle. And then, of course, apropos of our panel and conference, a tremendous amount of executive branch constitutional interpretation. Now, usually this is another point where this period makes an appearance in the con law casebook of Andrew Jackson and departmentalism, right? And one tries to explain to students how departmentalism would work, and they say, yes, but Andrew Jackson, and you say, yes, but let's talk about departmentalism, and it's challenging. And then, there endeth the 1830s, right? But here, instead, we have actual departmentalism coming from John Quincy Adams as Secretary of State, James Monroe as president, then Quincy Adams as president. And it's not the sort of usual forms of departmentalism. This story shows a lot more. And again, that there's actual constitutional interpretation going on, invasive federal power, again, in line, I think, with Nick's story. And so let me say a little bit more about those two things before finishing. So first, the invasiveness of federal power. I mean, I think we have this story of this is the period where, out in the purlieus of the Northwest Territory, one is untouched by federal power. Well, that's not, certainly if you're in a territory, that's not true. See Professor Oblowski and others. But states and the localities. So, it's not just congressional power, but it's executive power permeating Charleston and elsewhere. You have the revenue officials, the port officials, and the sort of awareness of the federal judiciary. And Johnson is someone who's writing to President Jefferson and others. And so there's a kind of pervasiveness of the federal government and the executive branch. And then the connection to the sort of lawmaking or constitutional law interpretation through the executive branch and through the person principally of the Attorney General of the United States. So Jed has written extensively and wonderfully about this. And here we get this Attorney General opinion from Attorney General William Wirt, who had indeed argued Gibbons versus Ogden a few months before. So again, the presidents say, we have this problem in Charleston. The British are very upset about their ships being stuck in port. It's important that they be able to have their crew from all over the world. Many members of the British Atlantic sort of sailing force are just in the period designated as free people of color. And so the president says to the Attorney General, write a constitutional opinion about this. Now, this is sort of unthinkable to us that anyone would that this is how it would work and that people would really kind of care about this. And so in parallel with the kind of Gibbons versus Ogden theory of the commerce power, exclusively federal, you get this Attorney General's opinion where Wirt draws on his arguments in Gibbons, talks about commerce as intercourse, which was something that he had framed in the Gibbons oral arguments. And so it doesn't work. It doesn't tell South Carolina, oh, you're right, the president says this. In fact, they love the idea that now they get to add another federal official to the list of people whose authority they're flouting. But I think all of this suggests, again, the sort of constitutional kind of interpretation that's really going on within the executive branch, not just from the president. You have the cabinet really active in this. And this question of when did the founding end, I think if you ask people in the 1820s, they were struggling with that question. But if we don't talk about this period, we're missing out on an important source and method of thinking about constitutional law. Thank you.
Great. So let me start for Jed, Mike, how much, since I managed to screw up the clock a bit, how much more time do we want to take on this panel, Morgan?
You are slated to go until 10:30.
Oh, okay.
You want to go a few minutes over?
No, but that's okay, that's reasonable. So I think what I'd like to do is, I think I will try, the standard role of academic commentator, make a quick comment, question or two on each of the papers. I'll just do that, I'll do them all seriatim, but straight out, and then you guys can, reply as you want. And then we'll open it up, so that'll give people in the audience time to think. So Mike, I'm going to start with you. I agree in many ways with your characterization of the different sources of evidence and how we bring them to bear. I mean, in a sense, I wrote a whole book on this subject that came out, and I actually started thinking about this really back in the early 1970s. I mean, this has been a long-term project of mine, back when I was in graduate school. I agree that I think, I spent a lot of time thinking about the Pacific-Helvetius exchange. In the end, Hamilton has an account that is more telling and is more effective. And I think Madison felt he was stuck with doing this. Jefferson drafted him into the project. He was stuck in Montpelier. He didn't have the sources. He kind of regretted it, and so on and so on. But, and so that's fine. But I have to say, I stumbled at one point. I mean, I just do not understand your meaning when you say what you're trying to produce is an original objective meaning of the words of the text to reasonably inform speakers to the exclusion of any kind of subjectivist factors. I mean, Hamilton, and even taking your example of Hamilton writing for the executive branch, of course he's writing anonymously to pursue policy objectives to which he was deeply attached. I mean, his whole theory of public finance, in the 1790s, whether he's Secretary of the Treasury or not, depends on maintaining, the flow of commerce between Britain and the United States, because that's the single most lucrative, essential source of public revenues to make the government work. So, I mean, you have a nice phrase, but I have to say, it just strikes me as being philosophically vacuous. I just don't understand what is the basis of your saying this is going to produce an originalist objective meaning of the words of the text to reasonably inform speakers. I just don't get it. I have to say, this morning I read, and I don't know if this is one of Julian's students, but the guy who's the New Yorker General Counsel put up this hilarious piece at the New Yorker about Alito's opinion under the title Fabio Bertoni. Does this mean, Yeah, but there's Samuel Alito's Amelia Bedelia reading of the Constitution, which I thought was quite a send-up. We don't have to go that far, but I really stumble, kind of like Samuel Adams reading the Constitution, We the People. I kind of stumble at your conception of, original objective meaning. I mean, I just, maybe I'm dense, but I just don't get it. So that's my response to you. To Aaron, I guess I would want to know. I mean, more than this original quirky board, the sinking fund thing and the controller of the currency. I actually had a college classmate who was controller of the currency, Yale lawyer Gene Ludwig, Haverford '68. But I was trying to think. I would want some objective case studies. I mean cases where presidents actually had cabinet officials with whom they had some divergences. I'm just free associating. The only one that could come up with, I think, and actually Amanda could help me on this, but I was thinking of FDR and Cordell Hull. FDR did not really want to have Cordell Hull as his Secretary of State, but Hull was, as I recall, was an important Tennessee politician. FDR wanted to rely, I think, on Sumner Welles, who was the undersecretary. In the end, Welles got the axe, and Hull was able to hold the job. But I was trying to wonder, do you have any case studies that would, for a historian, that's the kind of data we'd like to have, when it's available. And then the flip side of this is, it seems to me, you're asking the wrong question. I mean, the question I would ask, whether it's game theoretic or not, is based on recent experiences, it's the opposite problem. What do you have when a president willfully, in defiance of any notion of constitutional responsibility, much less any, I'm convinced the former guy had no intelligent understanding of the Constitution at all. A terrible joke was played on the American people when he swore the oath of office on January 2017. I mean, the guy was constitutionally illiterate and remains so to this day. But the scenario we've confronted is the president uses the removal power to get scrupulous officials out of the way. He uses, the appointment of acting secretaries. And you can tie that into January, if you do, I'm applying Occam's razor to January 6th, which is the best way to make sense of what was going on. Isn't exactly what the president was up to? So it seems to me the opposite scenario is actually a much more interesting one to think about. Nick, I thought it was a great paper. I think it fits in very well with Julian and Jed, all the other people who have been thinking about the delegation issue. I'm just drawing a kind of fairly, obvious comparison. Methodologically, it's really interesting to me. As a way of getting, I mean, it comes to go back to, to Mike's point. I mean, you're looking at early practice as being, if not completely dispositive, highly illustrative of, how the Constitution was understood and applied as these questions come up, in some sense randomly, because you can't predict what events are going to turn which clauses of the Constitution into actionable measures. I'd like to say the Constitution has lots of sleeper clauses. Like, we worry about sleeper cells. The Constitution has sleeper clauses that events mysteriously, motivate. And I think what happened in 1798, all of a sudden the direct tax state, I was interested that the 3/5 rule was applied. I was wondering where that came out. So I'm not sure I have a kind of critical comment for you. I thought the paper was very informative, the way all this stuff being done on delegation, non-delegation. Been informed. Also, the one point of your paper, it's slightly peripheral to what you're doing, but I think not really, is I've gotten really interested in the question of how do the state governments relate to one another, and also to Congress in what you're calling the interbellum period. And I know Chris Fritz has a big manuscript in the works on the whole notion of interposition and the attempt of state legislatures to, I think the word they use, they try to instruct their senators and request their representatives. I think that's the standard formula. But there's this guy, this unlikely name of Peveril Squire, I haven't met. He sounds to me like somebody who's wandered out of a Jane Austen novel, into the realms of academic scholarship. But he has a wonderful book that's sitting on my desk at home about mostly about state legislative instructions to members of Congress. To their delegations, perceived as delegations, which itself begs some questions about what the nature of congressional service is like. But it seems to me that's, I don't know if this figures in your story or not, but it seems to me this is this kind of really curious and intriguing aspect of federalism to which people, very few scholars have paid any attention at all. And I think it's related to something we mentioned briefly. I mean, the way Kate Mazur writes about this, the way the Massachusetts General Court sends a delegation off to South Carolina to try to protect the status of, Massachusetts being a big shipping center. And this actually goes back to my mentor, Bud Balin's famous monograph using the counter sorter on shipping in colonial Massachusetts in the 17th century. So there are these other dimensions of federalism that I think we have not just paid much attention to, would seem to be quite enticing and really deepen our appreciation of the complexity of the system. So I hope everyone can kind of, I'm not sure what Nick will have to say, but, hope if you want to kind of briefly respond to and then, we'll open the mics and, to the naysayers and, whoever else is sitting in the audience.
I'll try to be really brief in response. Jack, no, you're not dense. You wrote Original Meanings in 1997. It won the Pulitzer Prize. It frames a lot of these issues. It's been an ongoing, long-lasting debate. When you're engaged in the enterprise of constitutional interpretation, what is it you're trying to find? What is the ultimate goal? And the intentionalists will place primary reliance on subjective understandings and evidence of intentions. The view that I have is one that says that's actually not quite the correct goal of constitutional interpretation. The idea is to ascertain the objective meaning of the words. Now, the objective meaning of the words is certainly informed by evidence of subjective intentions and expectations, but it's a slightly different enterprise. You're not trying to ascertain what Madison thought and treat that as constitutive, or what Hamilton thought and treat that as constitutive. You are looking at what they thought and how they applied the Constitution as evidence of what the meaning of the words is properly understood to be as an objective sense. It's just different methodological premises, but my core point is that what you count as evidence of of the meaning of the Constitution turns a lot on what you think the enterprise is all about in the first place.
Okay, Mike, but I'll just make a quick rejoinder. If you go back and read Federalist 37, I mean, it's not for me like the morning schma, an image I sometimes like to cite here. But in any case, if you go back and read Madison's very brief distillation, which actually ties into the liquidation issue in curious ways, his very brief distillation of Locke's book, An Essay Concerning Human Understanding on Language and the Multiple Meaning of Words, and you're dealing with highly charged political speech, or speech which is by its nature has a political as well as a legal dimension. The idea of an objective meaning that can be isolated from a variety of purposes, it seems to me that philosophically and empirically, that dissolves. But we'll leave it there, and if this thought percolates in the audience, that's fine. Aaron?
Yeah, so I don't have any examples of the Sinking Fund Commission. I do have
I
examples
mean,
of
other than the sinking fund.
No, where there was,
Okay, yeah, yeah.
where they disagreed with the president wanted to toss them and didn't. Certainly examples of the comptroller, where the president, there's a comptroller who is lobbying against a bill that the president wanted. And the reason they say, well, we can't fire him is he's like, this guy's got all these friends on the Hill, and I can't go after him, he's untouchable. And as to the wrong question, here's the thing. All of these use of actings, I agree.
Yeah.
All the things of actings, that's by statute. And in fact, who are the people who are on the Supreme Court who are most against that? It's the conservatives. The way that you cut off the actings is Justice Thomas has his decision in Southwest General, which is you can't use actings for principal officers. That's as a constitutional rule. That would cut that off big time. And remember the appointments clause, recess appointments. It's the conservatives who are much further, which would cut all of that off. But it's interesting, at the same time they're doing that, they're de facto creating independence within the executive branch. So there's some tension between that and the Saylor Law Collins line of cases. But that is the way it gets cut off. So I don't think it's a separate question. It's the same question, as we explained in a longer paper. So
Good to know.
thank you.
I do want to make a comment, Jack, in response to what you said about there being sleeper clauses of the Constitution, because I think it goes to a significant methodological issue related to what Michael was saying in his presentation about the interpretive relevance of early practice. So when we talk about the probative value of early practice, there's quite naturally and intuitively, and I share this intuition, a tendency to say that the probative value diminishes as you get farther and farther from 1788. And that's got to be right in some sense. But under that rationale, we should really privilege the first Congress, 1789 to 91. But the first Congress, that period, 1789 to 91, is a very favorable period for the United States in terms of the amount of global international peace, the flow of commerce, the availability of easy finance through import duties, and therefore there's no occasion during the first Congress for Congress to activate a lot of the most important clauses of the Constitution, including the direct tax clause, which the framers absolutely went to the mat for between 1788 and 1791. It's probably the most contested clause of the Constitution that was not subject to an amendment in the Bill of Rights. So I think we need to be careful about how strictly we enforce the rule that as you get farther from 1788, probative value diminishes, because it may be only in 1798 or what have you that the occasion for some of these provisions to be liquidated arises as a political matter.
Yeah, that's a nice response. I mean, and I hadn't thought in these terms, but the independent variable, or since turning my sleeper clause notion into, in a sense, an independent variable of constitutional dispute or controversy, or just open questioning is a real sweet way to kind of reframe the question. Elson?
Yeah, just briefly, I think there's a lot to say in this period about the way that relationships among the states, between the states and each other, and the states and the center are very different from what we kind of think of today, again, as the modal federalism organizations. One point is just the kind of permeability or the interlocking nature of state representatives and state government and Congress. I mean, partially because of the way senators were elected, of course, so there's more of a connection between the state legislature and the US senators from a given state. You see this in the South Carolina example of John Quincy Adams sort of calling in the South Carolina congressional delegation. As you said, that's how they think of them, as ambassadors, to say, you know, what's going on with this port bill? Can't you do something about it? You're the reasonable ones, right? And then also, you know, this dinner party example, I mean, this is the other thing. It's like the people who are in Washington are sort of hanging out together. So Robert Hayne of South Carolina clearly goes on some rant about what's happening with the federal courts, and there's the sense that Quincy Adams and other people are sort of like, well, that's embarrassing, we need to change the subject, but they're all sort of sitting there having dinner together. And then the last point I'll mention is just, especially so many of these instances are about ports and, you know, sort of migration, commerce, et cetera. And one thing that's notable is you have intra-state differences where the law is being made by a state capital, delegates in a state capital, which is not the port city. So Columbia is the capital, Charleston's the port, Annapolis versus Baltimore, New York versus Albany, and you see the kind of port kind of grandees pushing back against the state legislators in some sense because they don't have the same interests necessarily.
Great. Mike, you get to ask the question.
Yes, I want to take off from your initial invocation of Federalist 37 and put a question to Nick and Allison about the difference between, the possible difference, at least the difference I tend to perceive, between a very early practice and subsequent practice, which the way I tend to think about this is that the very early years get special weight because of an assumption that those people shared the linguistic and sort of general worldview. They understood the founding in a way more directly than subsequent generations do, and thus I tend to agree with Nick that the earlier you are, the more probative it is as a matter of original meaning. But I tend also to think, and I think this is where I share Allison's point of view, that that constitutional interpretation doesn't stop there, and that originalism doesn't answer all the questions, and that sometimes there are ambiguities, sometimes there was an overlapping consensus that, you know, that only gets, you know, where the two sides of the overlap only come into war with each other later. Sometimes there are new developments under the sun that, you know, that require some kind of an interpretation. And I take it that Madison's view of how to deal with this, based on the passage that Jack read to us at the beginning, this is what he calls liquidation. He's, you know, a series of discussions and decisions, and I think the discussions is actually probably legislative or political, and the decisions are probably judicial. So you're referring to the two different kinds of precedent in and out of the courts. Seems to me that ceases to be originalism in the sense of the original understood meaning of the Constitution, but it isn't anti-originalist in that I think that it's within the contemplation of the original founders as to how the Constitution is going to be interpreted over time in light of their understanding of the limitations of language and so on, the considerations in Federalist 37. So here's really my question to Allison in particular, but maybe Nick would have a thought about it too. Does this period between the wars have special significance? Because there's also going to be constitutional interpretation during Reconstruction. There's going to be constitutional interpretation between the end of Reconstruction and, say, the rise of the Progressive Era. There's going to be constitutional interpretation in the 20th century. I mean, it never stops, right? And I would have thought that the force of Madison's argument for liquidation is that long-standing, consistent practice that cuts across, especially if it cuts across parties, cuts across ideologies, fixes constitutional meaning, even if it isn't an original interpretation. But I'm just wondering, so Allison, are you focusing on the period between these wars because nobody else has and it's interesting and fun, or is it because this period has more significance than, say, the latter part of the 19th century or the first half of the 20th century or any other period we might point to? I understand why the early years have special weight, but I don't understand why any particular period after that deserves more attention than any other.
Well, part of the reason is because, yes, there's the sense that it's been overlooked as a period and not kind of brought within constitutional history and intellectual history. But I actually think there is something special about the period. So I think, the Civil War and Reconstruction is shaped by this period. In the 20th and 21st centuries, we have tended to read the Civil War and after, we've tended to put those understandings of things like union. Well, when Daniel Webster talks about union and liberty now and forever, he means the union that will draft the Emancipation Proclamation. No, he doesn't. He means like a very compromised and different theory of union. So the mental shift and constitutional sort of worldview shift of the Civil War and Reconstruction, I think are different from this period, but shaped by this period. And we can't explain this period through the later one because, of course, the people in this period don't understand it, or don't know what's coming. So I do think it has uniqueness also because of the people living in it were, many of them, born during the Revolution and acutely aware. I mean, this is like Lincoln's Lyceum speech in 1838, where he basically says, we all know we missed the big events, but that's fine. Law is really important, and don't mob. The mob is terrible, and we'll just kind of try to not mess it up, because he's Lincoln in 1838. And so their self-consciousness about themselves as these sort of long founding moment dwellers, I think, is also significant. But, also I think there's going to be another volume that talks about the Civil War and Reconstruction. So.
I think I need to call it a wrap now, but no? Or Julian, did you have a question? Okay, sir.
This is a question for everyone who mentioned originalism. If the delegates of the Constitutional Convention destroyed their records day to day as they went, if they had an agreement of secrecy, and if James Madison withheld his notes for decades, 50 years, and they didn't actually even come out until after his death, does not the concept of originalism stand the founders on their heads?
No. Well, I mean, Madison, Jonathan, my colleague Jonathan just ducked out, but, Madison is clearly working out, though I think with a lot of problems, but is working out an early version of it by 1796, although it's meant in part on excluding references to the debates at Philadelphia, which remain, in a sense, a kind of privileged source for which there should not be general access. On the other hand, he comes up with an argument, which I think is problematic in some ways, but provocative and productive in others, that the collective public understanding, as expressed in the records of ratification, creates a legitimate constraint or framework for constitutional interpretation. So the idea per se emerges early, not without some problems, but it is an available mechanism of interpretation at a relatively early point in our constitutional history. Though I'd argue probably not in 1788.
Two very quick questions, one for Allison and one for Nick. The dynamic that you flagged, Allison, it has never occurred to me before about one of the important regional interests intrastate being between kind of capital cities, inland and port cities, important port cities that are just geographically differently located, and the way in which that could elicit some tensions. One thing that occurs to me, and this is just throwing an idea out, is that could lead to different views on the federal union, different views on like the federal government as a source of right? Like a different normative valence for the federal government, and maybe not in a deeply theorized way, but if the federal government is promoting what you like as the harbor master, that might play out over time, politically speaking, with connections of the populations of the region to how they thought about the federal government. So I just have this very encoded intuition that's super interesting, and I just wonder if there are ways to figure that out, or if you've seen indications of sort of a more state-oriented alignment by the people in the state capital and a more federal-oriented alignment by the people in the harbor regions. And then, Nick, so one of the things you're doing with this material is suggesting that we have evidence of qualifications and complex, multi-layered administrative scheme that's sort of asserted by Congress and sort of permitted as a matter of practice, accepted as constitutional. I wonder how to think about the fact that for centuries, the way they, like if you're going to go to metaphor for the crown, it's the sword, and if you're going to go to the metaphor for Parliament, it's the purse, right? Like the purse is, if anything is, the core power of that political entity that is the legislature, at least within the theory that they were operating in. Should that change? And that question wouldn't just be limited to what you're looking at, right? Like, ought we to think differently about how to read precedents that show either relatively more or relatively less, restriction on the executive when it comes to spendy things? Or is that the wrong way to think about it?
Do you want to go? Okay. Yes, thank you, Julian. I just briefly, that's part of why, I think your question is part of why Charleston is so interesting to me, because you have Johnson, who thinks he's very pro-federal power in lots of ways, but then you have others, Calhoun obviously, Pinckney and others, who are decidedly the opposite. And so, I mean, to me, there's a sort of greater theme, which is something I draw out in the book, too, of the valence of federal power in this period is all over the place. Like, later on, you see states, well, actually starting in the 1830s, states claiming states' rights to resist federal power because the federal government is the one pushing the Fugitive Slave Act, for instance. So you have states' rights claims by like Wisconsin and Massachusetts because they want to protect free black people or alleged fugitives in their borders. And so it's also kind of scrambling the 20th, 21st century intuition, I think, which is federal power goes in one direction and state power goes in another, substantively. And it's just kind of not true, like, because the South in this period controls the federal government for much of the period.
Thanks, Julian. I think it's an important question, how to think about fiscal legislation within the context of all legislation. I mean, as you know, there's this whole debate going on about whether and how to subdivide legislation in a colloquial sense, in the sense of just things that are enacted by statute, in terms of what the constitutional significance of the statutes are. Benefits and privileges versus binding us to private rights. Is taxation distinct in some way? And I also there's no doubt that fiscal legislation is of outsized significance politically in this period, and I mean, I think we know that from a whole line of scholarship on early modern England, exemplified by John Brewer, the idea of the English fiscal military state, that really England's tax capacity is what it allows it to build such a powerful empire. And then more recently, the work of Max Edling, who argues that basically the early federal government is intended to be some version of the British fiscal military state, but one that's more flexible and can kind of snap into being when it's most needed. I am not sure how much constitutional significance to assign to the undoubted outsized political importance of fiscal legislation for the building of states, of credible states in this period. I'll have to think more about it. Thank you.
And that's a wrap. Thank you all very much. So are we resuming at the top of the hour? Is that the 11?
At 11, yeah.
Okay, so we have a 20-minute break.